I have to confess that notwithstanding my grizzled appearance, I can still learn a thing or two. Case in point, the original title of this speech was actually Socialization of the Judiciary. And I got an email from Yoram asking me, well, what do you mean socialization? And I realized he thought I meant like socialization of healthcare, right? I get it. Can you imagine anyone suggesting that anything could go wrong with a government monopoly on the provision of a critical service such as legal adjudication? No, that was not my intention. Rather, what I'm here to talk about is a generation of experience as a litigator that has caused me to realize over the last few years that something has definitely changed in the way judges decide opinions. Not just that they're a lot stupider. No, I'm describing an insidious internal shift driven by the pace and fabric of modern communication. Let me start with a stark contrast that sets the stage for my thesis. Imagine, if you will, a contentious legal issue erupting in the courts 35 years ago, which just happens to be around when I started practicing law, late 1980s. A federal judge in California rules on a hot-button case involving immigration or affirmative action. And how does that decision ripple through the judicial system? Slowly, painfully slowly. Other judges might not learn about it for weeks, through legal journals, circuit digests, maybe a mention in the New York Times or the Wall Street Journal. It might not find its way into an advocate's submission to that court for years. So at least notionally, there was time for reflection, for independent analysis, for decisions rooted in law rather than headlines. Judges did operate in relative isolation, and they were somewhat insulated from the frenzy of immediate peer pressure or public outcry. And lawyers of a certain age will remember researching the law through the use of the West Key number system, decennial digest, Shepard's pamphlets, advance sheets. What's an advance sheet? It's a report of a case that I, as a young lawyer in Midtown, could read only weeks after they were decided, instead of waiting until they were included in official reporters a year or more later. Now it's 2025. That ruling in California hits the wires in seconds. It's dissected on CNN, amplified on Fox, debated on X endlessly, dissected by legal bloggers before the ink is dry on the opinion, if there's such a thing as ink. Activist courts issue provocative decisions that go viral and rapidly shape, here's the key word for today's lesson, a judicial consensus among judges nationwide before anyone in chambers has had a chance to think about an issue independently. What are all the other judges doing? If you litigate public policy issues and you haven't heard that without actually hearing that during oral argument, you're not listening. And that's my thesis. Unlike the situation 20, 30 years ago, judges' decision-making is now powerfully affected by this development of instantaneous judicial consensus. I'm not just talking about the press and social media, but it's a judicial consensus on emerging and contentious legal issues. It's fueled by real-time news about how prominent, yes, often activist courts have ruled, and their rapid amplification of those rulings and the endorsement of those decisions by legal experts and politicians in corporate and social media. It's not merely a technological change, it is a social and cultural revolution, and it affects the judiciary, and it erodes impartiality and encourages activism. And while I'm not sure of any way that I or anyone else can stand athwart this development, I can at least stand here and yell stop, which I do, because this phenomenon inevitably tilts the scales against conservative legal adjudication. If you just listen to Josh's description of how the cases went, and Ted's description of the timing and the shadow docket, you can see this in action. So, again, you have this almost monastic process that took part before the digital age. Judges relied on briefs, precedents, their own chambers, And again, there was socialization among judges. They socialized, they discussed things. You have the Judicial Conference, God bless it. A study from the early 2000s reflecting on the 1990s judiciary noted that public opinion and media had some influence, but it was mediated and delayed. And judges could afford to ignore the noise. You didn't have the 24/7 news cycle demanding instant reactions, social media mobs, hashtagging impeach Judge X, Judge Y. Decisions were made in silos. Now, the extent to which this aligned with originalism could be debated. It didn't always. But we can still contrast that experience with the post-internet judiciary. Broadband, smartphones, social media, and social activisms have compressed, that doesn't make any sense, social media and the social activism these technologies have enabled have compressed time and space. We're all affected, and so is the judiciary. Now, I'm going to stick my neck out here and suggest that judges, like many or perhaps even everyone on this panel, are human. They read the news, they scroll through social feeds, they absorb the cultural zeitgeist to differing degrees. I mean, remember, the average federal judge is still 7 years older than your speaker. There are still a lot of old judges out there, and they really don't want to go. But their clerks are reading, their family members are reading, their colleagues on the bench are reading. And of course, again, that's always been true. But this feedback loop of consensus inevitably influences outcomes in ways that have to dwarf the relatively tame press coverage of the judiciary of a generation ago. Now, every controversial ruling results in a viral storm. Judges become household names. Courts in remote places such as Hawaii, Bill Shipley, are suddenly and instantaneously elevated to historically unprecedented prominence. And the social cadre of honest, sincere, and hardworking judges, absorbed as they are inevitably by this amplified narrative, have to feel the pressure to align with this rapidly crystallizing judicial consensus. And I'm just talking about the honest, sincere, and hardworking ones. So let's consider the 2017 travel ban executive order under President Trump. District courts in Hawaii and Maryland issued injunctions almost immediately, rubber-stamped copies of each other. These rulings, separated by half a world, weren't isolated. They were built over each other in real time, something that could not have happened in the 80s or 90s, couldn't have happened. These judges didn't even know that each other existed. But now you have a consensus, a judicial consensus. And quickly, appeals courts are citing these district courts' decisions. Social media amplifies it further. Activists, celebrities, fellow judges are retweeting the analyses, or maybe the judges aren't retweeting them, but the legal opinions are turning into viral content. Same thing happened after the 2020 presidential election, as any lawyer involved in those court challenges can tell you. A judicial consensus gelled quickly, and the taste of the resulting confection was that no election challenges by Trump forces would be considered seriously by any court at any level. And this result was reinforced by the media, by academia, and all respectable opinion. It was decided in weeks. So why do I stand here and say that this empowers activism on the left? Why should this not be an outcome-neutral phenomenon? Well, because activism gets more pixels, gets more virality, gets more support in developing that consensus. Whether it's immigration, abortion, gun rights, transgender nonsense, judges are celebrated, courts are celebrated, the institution of the judiciary is celebrated when it strikes down or enjoins the enforcement of a statute or a regulation or an executive order. Who needs the NCAA tournament when you can check the latest circuit-by-circuit judicial score of evil Trump versus the children. With apologies to my friend Josh Blackman, I'm not predicting betting pools on the outcome of judicial challenges. But there's no question that rulings that push back against political change get the lion's share of favorable media and social media coverage. Is it possible that this doesn't affect the judicial process? Let's consider the media pylon after the leak of the Dobbs draft opinion in 2022. There's a reason it was leaked in the first place. If there had been no social media, who would you leak it to? The Times? They would have been hung and quartered. There's a reason the decision was linked, because that leak had an immediate effect on every lever of political power, obviously including the judiciary. Lower courts scrambled to issue opinion on state abortion laws, again, citing each other's hastily formed consensus view. Social media exacerbates the whole process. Judges face online harassment, doxing, or praise. It's got to get to you. I now have cases where every single, and I literally mean more than one, every single ECF entry results in social media activity. Could judges ignore this? Can judges' chambers ignore this? They don't. And so from a conservative perspective, this has to make you feel a little bit uncomfortable. National conservatism, all conservatism stands for sovereignty, tradition, the rule of law, and not the rule by a media mob or a social media mob. The effect of this existing and developing and accelerating social culture accelerates the mob mentality. And while we may debate whether they need any more encouragement, this phenomenon absolutely, in my opinion, encourages judges to act as policymakers and to be the good guys on the interwebs. So what do? We can't stop everyone in chambers from doing a full social media workup of every lawyer and party that appears before them, and they do. They do. And that's why most litigators don't do what I do on Twitter. But I'm not most litigators, am I? But perhaps the Judicial Conference can initiate ethics codes, practices that limit judges and clerks' exposure to media during cases. I don't know. We do need to take a serious look at the case assignment system, which no litigator I know believes is random. Does anyone? Seriously, come on. That's over, right? That reinforces echo chambers. Obviously, conservatives must reclaim the narrative on social and corporate media to the extent at all possible. That is part of what I do and what Will does. And we also need to push for transparency in the social media algorithms that amplify activist rulings. Again, transparency. We're not making them change what they do. They're private companies, but let us in on it. At the same time, by the way, we should reckon with an arguably counterproductive level of transparency generated by universal 24/7 access to digitized legal proceedings. This inevitably improves judicial accountability, but it's an open question whether it improves legal outcomes. I don't think it does. Now, I just want to make an important point. Everything I've said here is just the product of my observation from 35 years of legal practice. I'm not privy to the secrets of the robing room. I've never been. I'm not a former clerk. I don't socialize with judges. I once almost said hi to one at Stop and Shop. I'm just a simple city litigator and I don't miss the decennial digests. I love me some internet. But I can't deny that in my work, I can tell that judges are looking over their shoulders with concern over how their rulings will play in a way they did not in the ancient times when I started practicing. And it's not entirely me. It's not entirely, personal. A 2023 study from the International Journal on the Commons of Administration, I never missed an issue of that, found that media and public opinion do directly sway judicial opinions. So Well, for some of the revanchists among us, it's disturbing enough to observe the comfort with which even Supreme Court justices sign on to opinions incorporating internet tropes and slang, which used to just be the privilege of ex-activists. The real concern is that judges in high visibility cases are going to and are conforming their rulings to perceived norms, to judicial consensus, to avoid a social and professional backlash. So look, yes, the judiciary was meant to be the least dangerous branch, exactly as James explained, a bulwark against fleeting passions. But in this era of real-time news and social amplification, it's becoming a mirror of those passions. And in fact, the judiciary can reflect them faster than any other branch. Certainly the legislature doesn't do anything. And the executive doesn't do anything without the permission of the courts. So for the sake of our nation, our conservative principles, let's get those judges off their phones. Thank you.